Today, I'm going to tell you a story. It's a true story. It's the story of my work on the Dolores I. Todd case. The reason I'm going to tell you this story is I believe it demonstrates two things. First of all, it demonstrates why I should be nominated to the Court of Appeals, and number two, it demonstrates why I want to be on the Court of Appeals. This case came to me through two of Dolores Todd's children. They came to my office and they explained to me that they believed their mother wanted her children to inherit equally in her estate, but it didn't look like that was going to be happening. I listened to their story and I found it very compelling. At that instance, I was not able to give them an immediate answer because what I wanted to do was thoroughly read through the will. I also wanted to make sure that I knew exactly what the case law was at that point, and I told them that I would get back to them. The attorneys in the room know very well that the intent of the testator is Polestar, and that the analysis in this area is well established. There's well over 100 years of case law exactly on this point. But I was unable to come to a conclusion. I was not able to give my clients an answer of whether I could help them or not. The only conclusion I came to is that I agreed with Justice Weaver, who in 1921 wrote, "I'll admit the soundness of the oft-repeated rule that the intent of the testator is the Polestar for judicial guidance. But confusion arises and becomes worse confounded in the apparently hopeless inconsistency of the courts in applying these rules to concrete facts." Not having reached a concrete conclusion, I reached out to others. I asked our intern to write a memo on this issue. I spoke with attorneys who had a lot of experience in this area. I wanted to talk about the status of the law. I'm going to pause a moment from the story because this demonstrates a few things. One is I have an insatiable drive to understand what the law is and its nuances. And it's this that gets my blood pumping. This is what I love doing. Two is I am more than willing to question my own thoughts and to challenge my own conclusions. Finally, I'm eagerly engage others to find out what the right answer is. At this point, back to the story, I write my clients an opinion letter. I wanted to know what I found. And the import of the opinion letter is that I know firsthand that what I find to be a fascinating puzzle or intellectually interesting does not comport to what my clients' needs are. They need concrete and direct answers to their real life concerns. We decided to file a petition for declaratory judgment because we wanted to find out what the district court thought of what the intent of the testator was in this will. Unfortunately, the court did not agree with my client's interpretation of the will, and I had the unpleasant experience of telling my clients, "You lost." After this setback, we talked about what we were going to do next and decided to appeal because we thought that one of the court's rulings on one of the issues was inconsistent with its ruling on another issue. I independently briefed to the Court of Appeals and independently argued to the Court of Appeals. At this point, I want to make 2 points. That although I'm more than willing to seek counsel of others to collaborate on an issue, I do not shy away from what I think is right. Also, last week, in speaking with many of you, you had asked me to address the fact that I'm a private attorney and I'm asking you to nominate me to the Court of Appeals. And was I skipping a step by not being on the bench? My answer is no, because the work that an attorney does in going through litigation is very similar to the work that a judge does. An attorney will prepare a brief for a motion for summary judgment, will prepare a pretrial or post-trial brief, will brief the Court of Appeals, and that is very similar to what the judge does. We set forth the facts, set forth the rule of law, and then analyze the case based on the rule of law and apply those to the facts. The only real difference is advocacy. And don't get me wrong, I love advocating for my clients, but the prospect of being on the Court of Appeals and that my entire job, my sole duty would be to simply get it right, would be an honor and a privilege, and would be the most satisfying and rewarding job I can imagine. Back to Dolores Todd. We lost the appeal. Although the Court of Appeals went out of their way, I think, to express sympathy for my client's position. But they said their hands were simply tied, that the law of the land would not allow them the relief that they were seeking. But this case, I think, is an excellent example of exactly why I want to be on the Court of Appeals. Quite frankly, it makes me crazy when I see the law being inconsistently applied. It's a problem for judges when they don't have clear guidance on how to apply their rulings. It's a problem for attorneys who are unable to give the proper legal advice to their clients. And it's, most importantly, a problem for Iowans who are unable to plan their affairs and conduct their business when they don't know what the outcome will be. I believe I have a keen eye for just this type of problem where you have inconsistencies in the law. And I want to be on the Court of Appeals because I want to address this. I want to make an attempt to close the gap on those issues. I also want to be very clear that I am not critical of our courts. In fact, in the Dolores Todd case and in all of my cases, when I discuss with my clients whether or not they want to appeal, I will tell them, of course, I don't know what the outcome is going to be, but I can tell you with certainty that the Court of Appeals will do an amazing job of understanding your case and will give every consideration to your arguments. As for the rest of the story, after receiving an unfavorable district court ruling, an unfavorable Court of Appeals ruling on the declaratory judgment action, my clients and I decided that we would take this to the jury through a will contest. I was sole counsel for my clients for a 4-day jury trial, and my clients were vindicated that their claim that their mother's last will and testament did not express her actual intent. And now that concludes my story. I would open it up for questions.
And we'll start questions with Commissioner Picklett.
Thank you. Thank you for your application. So I, at some level, agree with you about there's no perfect resume for the Court of Appeals, and simply because your background is solely in private practice, I think making sure that there's a breadth of experience on the Court of Appeals actually offers strength to the body as a whole, personal opinion. But I also think there's value to this group in understanding how you would get up to speed on areas of the law that you haven't practiced in as much as you've practiced in others, specifically criminal law. Mm-hmm. So if you could take some time and talk about what you would do, knowing that that's an important piece of what the bench hears, I think there'd be value in that.
As for criminal law, the first thing I want to point out is when I was a student at Creighton, we were able to do areas of concentration, and so the majority of my elective courses were in criminal law. Now, for reasons that I don't need to get into right now, once I began private practice, I didn't really get to do a lot of criminal cases. I had some felonies, handful of misdemeanors, but I did not have that many. But what I do have is a base for criminal law and criminal procedure. And I realize that the law has changed, especially in the realm of search and seizure. So to get ready, I will read and read and read and read, and I would love to talk to anyone who would like to talk to me about that.
Thank you.
Commissioner Stanger.
Thank Thank you. Thank you for your application. Our Court of Appeals is known as a very collegial court. How would you enhance the collegiality of the Court of Appeals?
Me personally, I'm excited about it. That's what I love to do. I love to talk about things and figure out how they work. I think it is an amazing system that when a case goes to the Court of Appeals, you're being heard by at least three different judges. I think that's an opportunity to get things right, to share how you're viewing it, and also get feedback from others to challenge how you look at it. So I am excited to engage in that. Thank you.
Commissioner Hoig?
Hi, thank you for your application. Kind of piggybacking off her question, if you and another judge maybe have a difference of opinions on a particular case, how would you handle that?
What I would seek to do, first of all, is make sure that I understand the other point of view. And that's going to either probably involve lots of questions. I am certainly not going to assume I'm right, they're wrong, or vice versa, but to make sure I understand. I find that many times there's a lack of understanding, and once that can be accomplished, that's when you can really make hay.
Thank you.
Commissioner Spies?
Thank you. Ms. Taylor, thanks again for your application. Is there a judge, either a district court judge or appellate judge or justice, whose career you aspire to emulate?
Just one? I'm going to talk about two different judges. The first judge I want to talk about is the late Jeffrey Paulson. He was a district court judge in the 3rd Judicial District, and I thought he was absolutely remarkable because he had the ability to judge the facts of the case and not judge the person. And I recall representing a person who was a former member of the military who had traumatic brain injury. And along with that, as you know, that can come with some very serious side effects, violence, drugs, that sort of thing. And instead of tearing my client down and taking his kids away, not taking him away, but not giving him physical care, he very carefully just explained to him that his actions were the reason that he did not get joint legal custody. But at the same time, applauded him for reaching out to the Veterans Affairs and taking advantage of the resources that were available to him. And if it had not gone that way, that really could have torn him down. And instead, my client took the visitation that he was afforded, and it really lifted him up instead of tearing him down. The other judge that I would like to emulate is Judge Tabor. I very much enjoy reading her opinions because they are so clear and concise, and it's that I think she has the ability to clarify the law and give useful useful guidance in its application.
Thank you.
Commissioner Hartkopf?
Thank you very much for applying. Can you just talk about your role in the Iowa Supreme Court Grievance Commission?
There was an opening, and I said that I would be happy to assume that role. I've never been called upon to do anything for it. So as of right now, I'm in my 2nd term, but I haven't had to do anything, fortunately.
Commissioner Semmelroth?
I really appreciate the story that you shared, the tenacity that describes for your client. In the Court of Appeals, we've been told time and time again that you're responsible for 100 cases that you have to write a year. How are you going to balance that tenacity with the workload that you have to get that many cases done? And is there maybe an example from your life that you could share with us that would assure us that you can do both of those things well?
Well, before applying, I had talked to Judge Gina Bating about this, and she talked about the staff attorneys that are available to each of the judges, and how that is such an invaluable resource in order for her to get her work done. And honestly, I have not had the experience. I haven't worked, in a small practice, and we just don't have law clerks, so I have not had that fortune before, but I would be ready to make use of that, absolutely.
Thank you.
Commissioner Henderson,
I have no questions, thank you.
Commissioner Roberts,
No questions, thank you.
Commissioner Hanson.
Thank you for your application. We've talked a lot about the workload with the Iowa Court of Appeals. How do you balance the need to process those decisions quickly, but also to be very thorough?
First, I want to say that I think there are many cases that will be before the Court of Appeals that I would be able to pick up very quickly without the need for all of that extra research. I agree that if there is a criminal law question, I would need to do more research, but there are many other areas that I am absolutely up to speed right now. And I would approach this as I do with anything in my practice. I triage, get done what I can quickly, and those things that I can't get done quickly, I spend more time on it. I think I've done a great job with my time management, and I understand how to get things done. I'm also have no problem working on weekends and nights and all of that. So I know it will be challenging, and I'm not afraid of that.
Thank you.
Commissioner Schnur.
Hello, Sailor. How are you?
Good, how are you?
Good. You're from a rural area and a small firm. Can you talk about that and how you think that you coming from that kind of a background and having that kind of a practice and experience might impact the Court of Appeals?
I would say in my community, it's a small community, and although I don't necessarily know all the clients that come in my door, I come from the kind of community that everybody kind of knows everybody, and when I have a case go from start to finish, if I didn't know that client at the beginning, I sure did know them at the end. And what that I will bring to the Court of Appeals is that sort of sensitivity to know that these cases have a real life impact on the families, the business owners, the farmers that I have represented, that it's real for them, and I can see that.
Thank you.
Commissioner Graber.
I know we don't have a lot of time. You tried to make a very good case about the similarities between an attorney and a judge, and really honed in on that. What have you done? And I think sometimes we can have a certain perspective until we look on the other side of the bench. So have you done some exploration about what it looks like of those challenges on the other side of the bench and to prepare you for this position?
I have talked to some judges on the court. I've talked to district court judges, and also, like I said, Judge Bating and Judge Schumacher about what it's like to be on the Court of Appeals. So I feel like I am somewhat aware. I do think that going from a district court judge to the Court of Appeals would be very different, because the district court judge, I think, spends a lot of his or her time answering the queue, just organizing, doing a lot of scheduling, doing that sort of thing. And I realize that really is a lot of juggling. I think that the Court of Appeals has maybe depending on who you are, kind of a nicer schedule as far as getting those cases in front of you and then processing the cases without necessarily getting all those phone calls, without getting all the queues answered and that sort of thing. I actually think that in private practice, although I'm not answering the queue, my life right now looks a lot more like a district court judge, and I've got the phone ringing all the time, I've got emails to answer, I've got clients to talk to. So it's, same thing, different hat.
Thank you.
And our time has expired, so we thank you for your application and wish you the best.
Thank you very much.
Thank you.